Hi folks, so what we're doing today is we're going to talk about the criminal process. The first thing to discuss are the classification of offences. Now, every single crime is put into one of three categories. It's either a summary offence, a triable either way offence, or an indictable offence. So if we just look at those three in order. So number one, what is a summary offence? Well, these are not very serious crimes. They're still crimes, but they're not very serious. They include things like assault and battery. Now, as a result, they are always heard by magistrates in the magistrates' court. Magistrates will hear 97% of all criminal cases. So most cases are going to be heard by the magistrates. Now, summary offences, because they're not very serious, you can only be sent to prison for 6 months. The government is currently looking at changing that to 12 months. So this may be out of date by the time you listen to this or by the time it comes to your exam. But that's okay, because for your exam, you only need to know what's happened in the past, or anything that's happened in the past 12 months doesn't matter. So at the moment, just stick with magistrates, 6 months in prison. They can fine you. This used to be £5,000, but now is actually unlimited. So for more serious offences like drink driving, they fined Ant of Ant and Dec, I think nearly £90,000 when he was caught drink driving. So summary offences, least serious, magistrates. Triable either way offences, these are kind of the mid-range offences. So things like theft, ABH, GBH section 20, and burglary. So these mid-range offences, triable either way, this means they can either be heard by magistrates in the magistrates' court, or they can be heard by the Crown Court. So a jury if the person pleads not guilty. So the Crown Court would have a jury who decide the verdict. That's 12 people if the defendant pleads not guilty. And if the defendant pleads not guilty in the magistrates, then 3 magistrates will hear their case. There are rules about what happens when you plead guilty and not guilty to a triable either way offence, which we will come on to shortly. The magistrates, if they hear a case and they don't feel they have high enough sentencing powers, then they can send it to the Crown Court for sentencing. But we will come back to that on the pre-trial procedure. And then the final category of offences, indictable. These are the most serious. Murder, rape, robbery, manslaughter, things like that. They are always heard in the Crown Court. So if the defendant pleads guilty, the judge, a single judge, will sentence the defendant. If the defendant pleads not guilty, then the case will be heard by a jury, and the jury will decide the verdict. So I mentioned just a bit earlier about the pre-trial procedure. So what we're going to do is talk about the pre-trial procedure for all 3 categories of case. Okay, so first of all, let's start off with a simple one. So the pre-trial procedure for a summary offence. So this is what happens before the trial. So magistrates aim to hear cases as quickly as possible. If the defendant pleads guilty, and apparently 90% of defendants do, and has legal representation or doesn't want it, then the case will be heard there and then, and the defendant will be sentenced. So it's very quick. You plead guilty, the magistrates just run through the facts of the case, and then they sentence you. Sometimes you don't even have to go to the magistrates' court. So for minor driving offences, you can actually plead guilty by post, and that's fine. If the defendant pleads not guilty, the magistrate will listen to the defendant's evidence and ask questions, and they will try and proceed as quickly as possible. So a date for the trial would then actually be set. So they would just ask a few preliminary, difficult words, questions, and then they will ascertain what's going on in the case and then set a trial date. And then when that date comes, they will listen to the facts, listen to the defendant, listen to any witnesses, and decide their verdict. Pre-trial procedure for indictable offences, you have a first hearing in the magistrates' court. Now, the magistrates will deal with things like legal aid and bail. What they will then do is send, i.e. they will commit, it's called committal proceedings, they will send the case to the Crown Court because they look at it and they know it's indictable. They know they don't deal with indictable offences. So they will then send it to the Crown Court. You can also have a plea and trial preparation hearing, PTPH. And if the defendant pleads not guilty, then a trial date will be set. by the court. And an indictment is prepared, and this sets out the charge against the defendant. And then also you have to have things like disclosure, where the prosecution and defence must disclose the evidence to each other before the trial. Now, pre-trial procedure for triable either way offences. This comes through the Magistrates Courts Act 1980, so it's definitely worth mentioning Magistrates Courts Act 1980. So what happens with these triable either way, like theft, ABH, burglary? There's a plea before the venue. So what happens here is the defendant is asked if they plead guilty or not guilty. Let's go with the guilty plea first of all. So defendant pleads guilty. The case is heard by the magistrates and a sentencing hearing takes place. Now, if the magistrates decide they have enough power, remember 6 months in prison, then they can go ahead and sentence the defendant. But sometimes, if it's theft of a large amount of money, the magistrates will look at it and think, actually, we don't have enough power. We have insufficient powers. So we are going to have to send this case to the Crown Court. So then they would send it to the Crown Court for sentencing, and the Crown Court would sentence up to the maximum that they can for that offence. So that's what happens if the defendant pleads guilty. So option 2, defendant pleads not guilty. So the magistrates decide whether they are able to hear the case or not. And this is called a mode of trial hearing. So if they decide they have enough powers to hear the case, then they will say to the defendant, what do you want to do? Do you want us to hear the case, or do you want to go to the Crown Court? So the defendant can choose trial by jury or can choose to be heard by the magistrates. So that's only if the defendant pleads not guilty, they have the choice. And you've got to think, which court would you choose and why? Well, in the magistrates, it's a lower sentence, it's a quicker trial, so therefore it's cheaper. You are more likely to be convicted though, but there is going to be less press attention, so you have to weigh it up. The option of going to the Crown Court, trial by jury, you are being tried by your peers. So actually, you're more likely to be found not guilty. But if you are found guilty, you are going to get a longer sentence. Okay, so that's the classification of offences and the pre-trial procedure. Tune in for the next video, which is going to be about the power of the magistrates and Crown Court and criminal appeals.